Hi, my name is Graham Hayward. I'm Managing Director of Housing Hand. Housing Hand are the leading provider of guarantees to the UK rental market. The conversation today is around the Renters' Rights Act, and that's so relevant for Housing Hand because we help manage the risk of those changes in the rental market. I'm delighted today to be joined by Ryan Heaven.
Hi, I'm Ryan. I'm a Consultant Solicitor at Woodstock Legal Services, and I deal with all things letting, so hopefully I'm going to be able to answer some questions today. It will make things easier if I start with some definitions, because we're going to be using a few terms over and over again, and it makes sense not to constantly interrupt and re-explain ourselves throughout. So when we talk about HMOs, we are talking about non-licensable HMOs. We're talking about the broad definition of HMOs. A property may require a HMO license if it's a HMO, but broadly speaking, you do not actually need a license for all HMOs. This is important in the context of Ground 4A for assured tenancies. PBSA. Now, purpose-built student accommodation are expected to be exempt from many of the rules of the Renters' Rights Bill. We do not yet know how they're going to be exempt, but it's likely going to be an amendment to a schedule of the Housing Act, which currently only applies to university accommodation. So PBSA will be exempt from most of the rules, but there are certain ways in which they will still be affected by things that are in the Renters' Rights Bill. So when we're talking about PBSA and things apply to them, we'll be specifically saying that. Otherwise, by default, PBSA do not get affected by these changes, other than to say that they no longer have assured tenancies.
Signing of tenancy agreements is an interesting challenge. My understanding is that during the implementation period, so once it becomes law, then it pretty much won't be affected about when you're going to sign it. It will be a subsequent year when the law is already enacted, and that will mean that HMOs won't be able to sign contracts before the 1st of March for tenancies starting afterwards, but PBSAs will.
There's almost two questions in one here. So one question is about this transition period. People worried about what happens if you sign up to a tenancy agreement now. And the answer to that is that 6-month window that they're concerned about, what to do with Ground 4A, that simply doesn't apply for tenancies entered into right now. But this is going to be a problem in 2026. So if we're saying you want a tenancy to start on the 1st of September, then quite right, you probably shouldn't be entering into before the 1st of March 2026. It's important to remember that this 6-month period only is about the tenancy being entered into. You can do a lot of things before entering into the tenancy agreement.
Yeah, and I think building on that, the marketing you can do before. You can't, so this year, as it's an implementation year, you can continue on until the law comes in, and then obviously that statute will override any contracts that are in place. So you can market and you can do what you normally do until that is effective. In future years, though, we see that this is going to become very much a two-tier market. So HMOs won't be able to go to market until the 1st of March onwards. PBSAs will be able to go continuously to market. So I think you're going to find that tenants will be driven that way.
So you can do all these practical things outside of a 6-month period. You can put it on your portals, you can take referencing, you can do all those sorts of things, but you cannot enter into the tenancy. This enter into wording is a little bit challenging for some people, because I think lots of people are going to think of really creative ways to try and get around entering into contracts. Now, entering into basically just means the parties sign and execute an agreement, which basically means there's 2 signatures on the document and then there is a date written on the document. Anything short of that, in theory, isn't entering into, but I personally would prefer not even making a tenancy agreement available to sign before 6 months. This is my personal stance on it, because there's other bits of contract law which basically say if you're presenting a contract to be signed, your acceptance of it is implicit. Why would you present them with a contract to be signed if you weren't already happy with it? So I wouldn't want there to be any ambiguity over this 6-month period. You can foresee that there's going to be some disputes in the court in the years to come over when a contract was entered into, I think, for the sake of a few weeks.
And it's easier to clarify that don't do it rather than think you're not entering into it in that definition.
Exactly. Why run the risk at all? So get everything teed up. And I think the important thing is that the tenant understands that there is an agreement in principle. It's just that the paperwork won't follow until a little bit closer to the time. As long as they understand, I don't think there's any reason why it should change anything.
And just to clarify even further, if you did do that, if you presented the contract before, it's not enforceable if they want to get out of it prior to that period anyway, because they can't enter into it and therefore the contract doesn't exist.
Yeah, I hear what you say with that. Yeah, so if the contract isn't yet enforced, then no one can really rely on the provisions within it.
Yeah.
We've had some questions about guarantors and particularly Tenant Fees Act. One of the questions was to do with whether or not guarantors are permitted under the TFA. What's your thoughts?
Yeah, so this has not really changed since the Tenancy Fee Act was in place back several years ago. So actually the Renters' Rights Act bill it does talk about guarantees, so it legitimises guarantees and guarantors in that context, so they're allowed. It's a question of how you engage a guarantor. So clearly, in the event that you can't take rent up front, your risk is going to change as a landlord. A guarantor may be one of the options that you're going to want to engage with. And I've been very specific here. You can ask anybody in the world to be a guarantor. It's the risk appetite of the landlord as to who they will select. Now, you can't mandate a service that is going to bring a fee with it. So the way that this works is that you can ask for a guarantor. If you want to offer a range of selections, which are personal guarantors or company guarantors, such as Housing Hand, right, then you can offer that, and none of those are against the Act.
Individual guarantors and company guarantors are treated slightly differently in renters' rights, aren't they?
Yes, so company guarantors continue on no matter what. In the event that you're a personal guarantor, and there's quite a lot of detailed provisions as family relationships that come with this next statement, but broadly speaking, if you're a personal guarantor and you have a personal relationship with one of the tenants and that person dies, then your guarantee will fall away.
So in many ways, company guarantors provide an extra fail-safe for landlords. Given that personal guarantors, there is a potential way out of that tenancy, albeit in fairly morbid circumstances.
Yes, regrettable circumstances, but I think that's the case. That's a practical understanding of how we see guarantees from a provider of guarantor services. But what's your perspective, Ryan, from a legal point of view?
Well, we've touched a little bit on the Tenant Fees Act so far, and the Tenant Fees Act does not prohibit guarantor agreements. That does segue us quite nicely into whether or not it allows third-party guarantors like Housing Hand to provide their services for a fee. Now, it's my opinion that it does, but I know that there's some opinions out there that say that it doesn't. So I just wanted to really drill down into that. Mm-hmm. The opinion that's out there at the moment is that you can't require a company guarantor for a fee unless it's an alternative to something which is permitted under the TFA. And the logic here is that rent in advance is currently okay, but it will soon cease to be okay. So if you do not have that permitted payment available, then how can you ask for a third-party guarantor to step in? Well, my interpretation of the Tenant Fees Act is that it's slightly semantically different to that. It isn't about whether or not the TFA permits something, it's about whether or not the TFA does not prohibit something. Mm-hmm. So as long as you have something which is not prohibited under the TFA as an alternative to a third-party guarantor, then that's perfectly okay. So the logic here is request the guarantor. If you're requesting a guarantor which is not prohibited under the TFA, then you can also, as an alternative to that, offer a third-party guarantor service. Now, whether or not they can provide a guarantor that is acceptable to the landlord really comes down to your own referencing criteria. But you mentioned appetite for risk earlier. I would say that if you have got a guarantor based overseas, a guarantor agreement which is based overseas is very, very tricky to enforce. I would say nigh on impossible to enforce proportionately. So if you were to insist on a UK based guarantor, and in fact, even if I'm nitpicking it slightly, I would say an England and Wales based guarantor, because it's slightly trickier to enforce in Scotland and Northern Ireland, not straightforward as just issuing a small claims court action. If you insist on there being a UK guarantor who meets referencing checks, that is not prohibited under the TFA. So that means if they can't provide a UK based guarantor that meets referencing checks, then you can also offer a third party alternative.
So it might take more operationally. You can't mandate a guarantor service, and particularly one that's fee paying, but you can say generally, I want a guarantor. Where you choose from, it really is open.
That's right, but the key word of much of a TFA is you cannot require someone to do something.
Yes,
but this requirement is underpinned by, or perhaps tackled by, this concept of choice.
Yes.
If you say you have option A or you have option B, take your pick, then you're not requiring them to do either one of them, and that's the avenue where you can get deposit alternatives, guarantor alternatives. All these alternative schemes come in with this choice. It's all underpinned by choice. They have to be given a choice which is not prohibited by the Tenant Fees Act. Like I said, the semantics there is not prohibited, which is not quite the same as permitted by the Tenant Fees Act.
Yeah, that's really clear. Just as a clarity, where you have multiple guarantors for multiple tenants, right, that will just continue on as it does today.
Yeah, there's no change in Renters' Direct about that. What happens if a tenant wants to give notice, an individual tenant in a joint tenancy? Well, there's two things that happen there. The current law is that if one tenant gives notice, they give notice on behalf of all tenants. So effectively, they're ending the entire tenancy by doing that. However, what happens if you have people stay? Let's say if you have 4 people in the property, one of them gives notice, that person leaves, but the 3 want to stay on. You can create implied tenancies. I don't think you would necessarily want to do that, but the service of a notice to quit by the tenant has to start some process to deal with it. You can't bury your head in the sand. You want to avoid a void period. You want to avoid 4 people leaving if you can perhaps retain 3 of them and just find a replacement. But it has to be some discussion. Maybe you say, okay, you treat it in the same way as you would perhaps an offer to surrender a tenancy currently. So you say, okay, you want to leave. You don't have the power to stop them, but you can try and salvage it so that the other tenants don't have to leave at the same time. You set things up to start a new contract with a replacement tenant being
and so that's a new tenancy agreement with different parties.
Yeah, indeed. So you have a new tenancy agreement. It may well be midway through the term, or it's likely to be midway through the term. You have to think about certain practicalities. So you treat it as an entirely new tenancy. So that means serving your EPCs and your gas safeties and things like that. You would also need to reserve your pre-notice for ground 4A as well.
Completely new.
Completely new, treated as an entirely new tenancy. But like I say, it's not entirely revolutionary, this. You just have to, it's just different.
Yeah.
So you just have to make sure your processes are in line to handle these kinds of requests, because they are going to come in.
But a notice from one is a notice for all, and it finishes.
Yeah, correct. And again, it's just up to you how you deal with it. If you're content with everyone in the house leaving, fine, you don't have to do anything. But I think you probably will want to do something.
And Ryan, you mentioned this one notice for one is one notice for all. Clearly, if you can't come to an agreement with the tenants and you're going to end the tenancy at that point, you're going to have a premature notice, really, from what you expected to happen under Ground 4A, for instance. So you might not have, therefore, your full 12-month tenancy, and you're going to have a void period. And actually at Housing Hand, that is exactly a level of cover that we're now starting to offer in the market. So we will be actually bringing not an extension to the guarantee, because the guarantee falls away with the tenancy, but we are offering for no fee to the HMO with a student where they've gone through this circumstance. We will be offering a complimentary service where we pay for half of the rent for 3 months, or up to 3 months. And just to clarify, that a void is available in the circumstance where they're a Housing Hand guarantor client. So if there's 3 tenants who are in the property, we will offer that 50% of rent for those that have guarantees previously in place for that tenancy. In the event that some of the tenants that were in that tenancies are not Housing Hand guarantor clients, then our cover won't be extended to that. So it's only available for the element that is with Housing Hand guarantees. So in typical student accommodation, there's a lot of sharing in terms of accommodation that goes on, and so you either have the concept of joint and several tenancies, but there's also individual tenancies. So for joint and several tenancies, if one of the people give notice is notice for all. What happens in the event that you have individual tenancies?
Well, it does make it much easier in a way, because if you only have one tenant, they give notice, then no one else is affected by that. You will have, I'm imagining here you're letting out a property on like a room let basis. So you might have multiple people living in the property, but albeit on their own tenancy agreements for their own room. That's perfectly okay. That's what a lot of people do currently, because it's not a given that they all need to be on the same tenancy agreement. It can be a way of containing risk, because obviously if you have a property with 4, 5, 6 people in it, and one of them gives notice for all of them, that can cause a bit of a headache. But if they are just giving notice for themselves, then suddenly you only have one room that needs to be let out. It's perhaps mitigating the risk slightly, but you could also view it through another lens, which is that if you have lots of tenants, one person wants to leave, you can negotiate with all those tenants, and they might be able to find people a lot better than a landlord or a letting agent can. They might know people who might need a room, in which case they are invested in finding a replacement for you in a way that they're simply not invested if it's just done on a room let basis. I mean, yeah, they'll have to live with the person who lives in the room, but they're not exposed if they fail to pay their rent or anything like that. So there are pros and cons to it. There isn't a best solution in my view. I think it really is just about your risk appetite, and I think containing it to room lets could have its pros and cons.
But it can be, and building on that, it can be a real pain if you're in a joint and several situation and you don't want to leave, and now you're being forced to leave because you've either
someone
fallen
else has
out.
given notice.
Correct.
Yeah, no, I agree. Like I say, it's possible to work with tenants if they're on
There's
this
a
joint
motivation
several.
to do that then.
Yeah, and if they want to stay and they don't want to rock the boat, then you've got some extra helpers, haven't you? You've got other people there who want to stay and they want to help you find someone to replace it. Otherwise, if they stay on, you can create a tenancy with just a remaining tenant if you wanted to. But obviously they would be individually exposed to that much more rent, wouldn't they? Because it's being shared between fewer people.
But that would be a new tenancy agreement, right? So because the old one is finished.
Yeah, totally new agreement. So you've got to reserve everything. You've got to serve your ground 4A notices again, things like that. So yeah, it's not without problems, but innately, if a tenant giving notice midway through a tenancy or expected tenancy is rife with problems. There are going to be obstacles here, and you just have to set up processes and I guess just deal with it as it comes. If the other tenants want to stay, try and work with them. If they don't want to stay, then at least you know where you stand and you can pop the property back on the market.